Okay, so any doubt from the previous class? No, all bodies done. Okay, so today law wala part we are going to cover is okay, basically about the criminal law. Hmm. So, so here we will cover entire things. Like for example, whenever any crime is going to be done, after crime there will be FIR, and after that there will be trial. Okay, whenever any crime happens, then will be FIR, and FIR के बाद arrest and then trial. Then first important thing is these things work on what basis, whether it is based on the constitution or there is any law based on that. So we are having basically three important law. One is called as BNS, second is called as BNSS, and third is BSA. BSA क्या है? बेसिक शिक्षा अधिकारी नहीं, yes, Indian Evidence Act actually. Okay, so this is Bharatiya Nyaya Sanhita, this is Nagarik Suraksha Sanhita, and this is Bharatiya Saksh. So this is basically, earlier it was IPC and this was CRPC and this was Indian Evidence Act actually. Okay, see BNS जो होता है, it talks about substance and this talks about procedure and this talks about evidences. Okay, when I say substance, it means it actually tells whatever act has been done, whether this act is a offense or not, it is mentioned under BNS. Okay, whatever the act, for example, whenever you are going to complain in the police station, someone has done this act, then police personnel is going to check whether this act comes under offense or not. So they will come to know only through BNS only, correct है ना? And BNSS क्या है? What is the procedure? How to deal actually with such offense? That is called procedure. And here this provide the evidence. What evidence, witness they can accept, all those things have been mentioned under this three only. So right now in entire country we are having these three. This is done, Abhi. Everything okay. Now next. Basically the stages. Okay. So first is whenever any offense, first stage क्या होगा? Anything offense will be done. Correct? Whenever offense done, then next thing is this: we need to inform about it to the police station. So second thing is information, that we can call FIR also or not FIR. Third, after information, police will going to do investigation. Clear? After only investigation, police may arrest the individual. Correct? After arrest, during that we will going to apply for bail also. Correct? And then court is going to try that. That is called as trial. After trial, judgment will come. Then against that judgment, we can appeal. Okay, these are the stages that is covering entire criminal. Done this. So this is the entire procedure. Steps are there whenever any crime is going to happen this way only. Okay, so next is, we will cover that offense later. There are two types of offenses there. One is called as cognizable and non-cognizable offense. Okay, cognizable offense क्या है कि there is a, for example, BNS is there. इसमें one schedule 1 has been given. In the schedule 1 there is a list of offense has been given. That is called as cognizable offense. Like in our constitution at the last we are having first schedule, second schedule. Same way in that BNSS also, when you read Bear Act, last में they have given schedule 1. So schedule 1 offense they are called as cognizable offense. Clear abhi? Because in cognizable offense only the term FIR will be used. In non-cognizable offense, term FIR will not be used. Their term will be complaint. ध्यान रखना. This was the question this year UPSC prelims. वहाँ पे they have mentioned कि cognizable as well as non-cognizable offense में FIR will be filed. In non-cognizable offense there will never be an FIR. FIR is always associated with the cognizable offense. In non-cognizable this is called complaint. Clear abhi? Done. Okay, so the term is coming that is called as FIR. So FIR basically means a first time reporting of the information. FIR means first time, or basically the full form is also first information report. Okay, so FIR simply means first time reporting of the information to the police, or first information report. Okay, the term FIR has not been defined anywhere. Okay, the term FIR has not been defined anywhere. So whether it is mentioned anywhere or not, so answer is yes. When you read this BNSS, there is a section 173. This is what mentioned in the prelims exam also. Section 173. In earlier CRPC, it was 154. Again, earlier CRPC, no need to remember. That is only for the law graduate only, those who are doing that. You have to remember just section 173 of BNSS. वहां पे this term FIR has been mentioned. Clear abhi? Then
Sir,
no.
the FIR is not mentioned in the constitution.
Constitution mein today nothing is mentioned. Okay. So
Okay.
today whatever we are covering, it is not mentioned anything. This is completely a separate. It is related to the criminal law. Clear hai? Even this should not be asked by the UPSC also. But they are asking, they think that you are going to become very good IPS officer, so they think that you should know about it. Okay, so this is basically general things we need to know about it. FIR mention where is BNSS में under section 173. So what is the essential things of the FIR अगर देखना, first essential thing is definitely about the information. Correct? Information. See, whosoever is going to report the FIR, that person is called as informant. If I will go to the police station and will ask for the FIR, then I will be called as informant. And the person who is writing on that particular page, that is FIR. And person who is actually, he was police in charge of that police station. Clear me? So first important thing is information. There must be information about a crime. ऐसे थोड़ी पहुंच गए, ठीक है? Second important thing is this, कि that crime जो है, crime offense, that should be cognizable or non cognizable. Cognizable. Cognizable offense. This is also must for an FIR. Clear? Third important, officer in charge. Okay, officer in charge, basically police. That person going to write the, or if it is offense is related to the women, if any women is going, then that FIR need to be written by the women police officer. Correct? That is also requirement, and this can be oral also or written also. So oral mein, for example, you are going to narrate the story, the police in charge is going to write everything, or you can yourself also you can write and you can give that. Okay, then Next important thing is jurisdiction. So jurisdiction or non-jurisdiction. Okay. Like if crime happened in Jayanagar 4th block, then you can go to Tilaknagar police station. That is jurisdiction. If crime, for example, happened in Whitefield and you are filing in Tilaknagar, okay, that is non-jurisdiction. And this is called as basically zero FIR. Clear, Abhi? Next thing is signature. So signature is very, very important. Without signature, it is not accepted. Clear? And then that should be entered into a book also. Police stations, they are having diary that need to be entered in the. Second is substance entered in a book. Clear हुआ अभी? So these things are required for the FIR. अब for example FIR लिख लिया, they have reported that FIR. That FIR copy, who can get that FIR copy also? So 3 individuals will be having that FIR copy. One, पुलिस स्टेशन, उसके पास तो हो गई, ठीक है, एंड informant also. Okay, so अब informant will get photocopy only, real तो नहीं होगा, ठीक है, that will be free of cost or informant need to pay the money, it will be free of cost. Okay, so supplied free of cost to the informant that or victim. Okay, they will get free of cost. And third copy जो है that will go to the magistrate. ओरिजिनल किसी को, ओरिजिनल ओनली पुलिस स्टेशन, ठीक है. So 3 individuals, 3 places they can get the FIR. Clear? Now next question is who can file an FIR? है ना, कौन FIR फाइल कर सकता है? Anyone? Okay, so first next thing is who can file FIR. So first is victim, correct? The person against whom the offense is committed, definitely he can file an FIR. Next is third person. Third person, any person with the knowledge of offense. आप रास्ते में जा रहे तो you have seen offense has been done, you can go to the police station directly, you also can file FIR. So third person also, ठीक है. Third is accused. So accused जिसने crime किया, he has done the crime, he also can go and can file the FIR. होता है ना sometimes कि you have done the crime and reach to the police station, sir I have done this crime, है ना, ठीक है. So यहाँ पे भी तो accused also can file an FIR, ठीक है. Next is police. So on their own information, sumoto police also can file an FIR. And definitely fifth is court. Court also can direct it. Anyone. Victim means citizen, non-citizen, anyone. Correct? They can file an FIR. Exactly, it is there. Victim can be anyone. Okay, होता है ना, माँ बाप ने बच्चों को पीट दिया, बच्चा पहुंच जाता है ना पुलिस स्टेशन. अब डेफिनेटली वहां पुलिस, बिकॉज दिस इज इंडिया, यहाँ पे पुलिस जो है ना, दे नेवर टेक एक्शंस अगेंस्ट द पेरेंट बिकॉज दे नो दे आर आल्सो हैविंग देयर ओन चिल्ड्रन. ठीक है. यूएसए में दिस इज सीरियस केस एक्चुअली. ठीक है. इंडिया में ऐसा सीरियस केस नहीं है. क्लियर दिस? वेयर? हाँ हाँ. नो, देयर इज नो सच एज लिमिट. सी, कोर्ट मीन्स क्या है? कोर्ट कैन डायरेक्ट फॉर एफआईआर हियर. Okay, here it means, see, it is who can file an FIR. So court क्या करे? Court will direct the registration of an FIR. Correct? Police can also file an FIR, also motivate. Sometimes, for example, whenever crowd is there, stampede happened, so police क्या करेगा at that time? Police will going to file an FIR against unknown persons because abhi police is not aware who is the accused person. So they will file immediately against unknown person so that कि जो law है that come in set in motion. Without FIR, police cannot do anything actually. That is the reason. First thing is they will file an FIR against unknown person. ठीक है. That is also possible. That is called as cross FIR. एक दूसरे के अगेंस्ट कर लिया. That is cross FIR. Clear? What if the police refuse to register an FIR? आप गए but police is not registering their FIR, then what is the remedy we are having? So first thing is this: we can go to the superintendent of police, SP of your area. You can send a written FIR application to the SP. Then SP is going to direct the police subordinate, or SP will going to take actions on his own also. So first is remedy is SP or any senior officer. So what if police refuse to register an FIR? So first is we can go to the SP. अगर ये भी नहीं सुन रहे हैं, then any senior police officer. Okay. अगर ये भी नहीं सुने, ठीक है, then judicial magistrate. Judicial magistrate. Like for example, chief judicial magistrate of first class, judicial magistrate of second class. ठीक है, but आप just remember judicial magistrate. So he can order the registration and investigation. Correct? अगर ये भी नहीं सुन रहे हैं, ठीक है, then go to the court. High court. Court means high court here because you are having a writ of habeas corpus, writ of mandamus under article 226, writ jurisdiction wherever. अब directly आपको court नहीं जाना है. ठीक है, because when you go directly to the court, then court will ask whether you have used these remedies or not. If you're not, then definitely court will say first you have to go there. ठीक है. So first we need to follow this path only. इतना क्लियर हुआ? Where? District collector. See, district collector will send you to the SP only, or directly. See, if district collector is accepting, yes, FIR should be there, he will going to make the call directly to the SP. So you will come directly here. SP will going to make call to the subordinate officer. Simple. Correct? But there are things. See, the thing is, people are not aware about these things because of that. अगर सोचो example, if you go to the police station, in police personally they are not writing an FIR. आप वापस आ जाओगे. But इसी के सामने if you say like this, okay, ठीक है, I will go to the SP office, or I will, then he will understand that this guy know actually. Okay, because who will going to take that case? If SP will going to order, then this is a problem for that police officers who is in charge there, because they are very small compared to the SP. The SP can direct that, and because whenever there is appraisal will going to happen, SP will going to write there, so promotion will not be happen. That is the reason is if you know these things, that is okay. Clear? Now types of FIR. Types of FIR. Okay, first is like jurisdictional, normal we have covered. Other is non-jurisdictional. That is called as zero FIR. This was also prelims question only. Okay, and one is electronic FIR. So this is already, jurisdiction means normal FIR. Zero FIR means simple is registered at any police station. Clear? Hai? So non-jurisdictional means registered at any police station irrespective of where offense has taken place. Okay, irrespective of wherever offense has taken place. Okay, so offense, for example, it is a moving train. Okay, and your theft happened, some assault happened in different railway station, but train was moving, so you can come. Now you came to Bangalore. Okay, and that case has happened in Tamil Nadu. In Bangalore also you can fire a zero FIR. Okay, and then this police station that this is a duty that they need to send this FIR to the respective police station where actually offense done. So now they will not having any choice to reject it because it is coming from the police station. Like for example, there is Asaram Bapu. Okay, so he was already in Jodhpur. So one girl actually has filed a case, okay, against Asaram Bapu about the sexual assault, okay, in Jodhpur, because in Jodhpur no police, okay, stations ready to take an FIR. Then she came to Delhi. In Delhi, she has filed the zero FIR. So once they have taken the zero FIR, they have transferred to Jodhpur. Ab Jodhpur wale, they cannot do anything. They have to proceed with it now. Correct hai? So that is the concept of why we call zero, because number will be given zero for that. The serial number will be there for the every FIR. So they will give number zero at it. Okay. And whenever it transfer to the right police station, right jurisdiction, then real this number will be given to that FIR. Correct? Earlier क्या था, this zero FIR concept, it is coming from Justice Verma Committee. Justice Verma Committee in 2013 after Nirbhaya rape case, he has asked, because at that time this was one of the major issue, because police personnel, they were fighting against each other whether this belongs to your jurisdiction or my jurisdiction. At that time he has given the concept of zero FIR, you should not fight. Zero FIR must be filed immediately. Okay, so this concept came, but in old CRPC mein, this was not listed. So in the new BNSS mein, under same section 173(1), zero FIR has been mentioned. Correct? So zero FIR has been mentioned under section 173(1). Clear? Yes. See, there may be like offense was not cognizable offense. Correct? Because people are not aware what is cognizable and non-cognizable offense. आप जबरदस्ती करो नहीं सर FIR लिखो, but that is not cognizable offense. Clear? Yes, that police will decide. ठीक है? So we can't decide actually. हमें पता होता है for this particular area जो है ना, आप if you write the pin code ना, you will get this come under, like this entire area is coming under Tilak Nagar police station. People are aware about it actually. ठीक है? So zero FIR concept was given by when? Justice Burma Committee in 2013. Now it is mentioned under BNSS. Yes, it is mentioned. Clear, Abhi? Now next is EFIR, registration by electronic means. So information about a cognizable offense may be given electronically here. Here information about a cognizable offense may be given electronically. ठीक है? Like through email also you can send. Done. But again it will not be registered. आपका काम हो गया send, but they will not register. Then it must be signed by informant within 3 days. That means, suppose example, I have actually sent a email actually to the Tilaknagar police station. I have filed an FIR electronically, but they will not take any action actually. Within 3 days, I need to reach the police station. I need to sign it. Then only it will be registered. So this is a requirement. So next is, it must be signed by informant within 3 days. Within 3 days. Okay. So it must be signed by the informant within 3 days. अगर नहीं दिया, then that FIR has no validity actually. क्लियर है? अब आपको लग रहा हो कि why this within 3 days? एक्सेप्ट कर लो. प्रॉब्लम इज दिस, इंडिया में फॉर एग्जांपल व्हेन आई नो दैट माय केस इज कमिंग इन तिलक नगर पुलिस स्टेशन, ठीक है ना, आई विल आस्क मेनी ऑफ द इंडिविजुअल्स फ्लड दिस पुलिस स्टेशन विद लॉट ऑफ एफआईआर. दे विल स्टार्ट फाइलिंग ईएफआईआर. बोट जो होंगे दे स्टार्ट डूइंग इट. सो पुलिस के लिए दिस इज अ प्रॉब्लम. So this is the reason is 3 days time has been given, and this is mentioned in BNSS also. Earlier these things were not mentioned under CRPC. Clear अभी? So EFIR done. AFIR means electronically दिया है, but within 3 days you have to sign it. डिजिटल क्यों, हाथ से करना है जाके, ठीक है, वहां जाके नॉर्मली, ठीक है, ये OTP वाला नहीं है. क्लियर? No, anonymous not required actually. You have to give your information. ठीक है, because you are giving information to the police only. The police need to know who are you actually, correct? Because later they need to contact also. Clear? Yes. Okay, see, there is a one limitation act is there. So limitation act work in the civil suit only. Okay, but limitation act does not work in case of FIR. So there is no expiry date for the FIR. If offense has been done when you are just child, today also you can file an FIR. See, so there is no expiry date for an FIR. FIR can be filed anytime. Clear? Because in many of the cases जो victim होता है, they are victimized, they are not having enough courage to go to the police station. After many months they came to know, yes, they are having courage and they can approach. So that is the reason is there is no expiry on FIR. Clear? कोई है पुराना केस, ठीक है, जो आपका हो? Okay. Then clear अभी? Next is yes. हाँ हाँ हाँ. So police will file against that also, but whatever actually this crime happened against that individual, he also deserves justice actually. Clear? Now next is whether preliminary inquiry is required. Answer is yes. Okay. Inquiry. Again, section 173(3). For you, there is no need to remember the sections. Okay, not important then. So this is again preliminary inquiry apply only in cognizable offense. It is applied in cognizable offense. Which offense? Where punishment is 3 years to 7 years. With punishment 3 to 7 years. So यहाँ पे जो पुलिस इंचार्ज ऑफिसर इज देयर, he will take the permission of DSP. He will take the permission of officer not below the rank of DSP. Okay, so here it requires the permission. It requires the permission of an officer not below. Require the prior permission of an officer not below the rank of DSP. Okay, so here officer in charge may conduct a preliminary inquiry may conduct a preliminary inquiry, basically to know that prima facie evidence exists or not. Okay, so because if prima facie evidence exists, then only police will go for further investigation. Correct? And this need to be completed within 14 days. 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 करेक्ट है. अब यहाँ पे क्या है कि दिस इज अ डिस्क्रिशनरी पावर ऑफ पुलिस इंचार्ज. इट इज नॉट मैंडेटरी, इट इज डिस्क्रिशनरी पावर. इट इज अ डिस्क्रिशनरी पावर, नॉट मैंडेटरी. Done this, it is a discretionary power. Okay, so he may or he may not. This was also prelims question only. Yes, जितना मैं बता रहा हूँ prelims question वो एक ही क्वेश्चन था, ठीक है. It was not three questions. There were one question only, three statements were there. ठीक है, clear. So why not this above 7 years, because वहाँ पे you have to find. Below 3 years there is no requirement. Okay, so this is the cases. Earlier actually क्या था कि this was not mentioned anywhere under CRPC. This was not mentioned. Earlier they were working based on the judicial cases. तो जुडिशरी में एक वन केस था ललिता कुमारी केस. तो ललिता कुमारी केस सुप्रीम कोर्ट says that within 7 days you have to complete the inquiry. But in BNSS they have mentioned now 14 days. Clear? Because होता क्या है कि whenever any kidnapping happened, for example, earlier this used to be happen कि बस child है, child is, you are not able to find your child, you will go to the police station. पुलिस वाले क्या बोलेंगे, 2-3 days आप वेट करो, बच्चा अपने आप आ जाएगा. जो अपने आप ही गया तो अपने आप ही आएगा. ये कैसा लॉजिक है? सो दे गिव सच लॉजिक. So this was Lalita Kumari also. She was a child, okay, 6 years. So she actually after 9 p.m. also she was not available. Her father approached to the police station. They have not filed an FIR. ठीक है. Approached to the SP also. Again same responses कि it will. अब 6 year 6 year का कैसे अपने आप आएगा? ठीक है. Then this guy approached directly to the High Court actually, and he filed it. This not even High Court, directly to the Supreme Court actually, because case was Ghaziabad. Okay, so Supreme Court only. So under article number 32 he filed a writ under habeas corpus. Then Supreme Court has asked the DGP that you have to produce the child tomorrow in the morning. ठीक है ना. अब क्या हुआ, एंटायर पुलिस जो है ना उत्तर प्रदेश, दे हैव टू फाइंड इट. डीजीपी का ऑर्डर है. देन इन द मॉर्निंग चाइल्ड वाज देयर इन दिल्ली. ठीक है ना. So then they have given this case within 7 days you have to complete everything, and this FIR registration is mandatory. अब यहाँ पे फॉर एग्जाम्पल फादर को किसी ने इन्फॉर्म किया होगा, ऐसा भी एक पावर है, इफ यू गो ओवर देयर. ठीक है ना. अब इफ यू डू नॉट नो देन यू विल रिमेन एट होम ओनली. ठीक है, क्लियर दिस. नेक्स्ट इज, अगर फॉर एग्जाम्पल FIR अगर ऑफेंसेस अगेंस्ट विमेन है, देन दैट विल बी डन बाय विमेन ऑफिसर ओनली. क्लियर. अगर फॉर एग्जाम्पल व्हेन विक्टिम ऑफ दिस ऑफेंस इट इज टेम्पोरली और परमानेंटली डिसेबल्ड है, then no need to come for the victim to the police station. Okay, then police only need to go to the house of that individual or wherever they find actually comfortable. Police need to go there only to get an FIR. ठीक है, because that person will going to tell. ठीक है, पर्सन ही तो बताएगा ना वो, कैसे पता चले. समटाइम्स क्या होता है, लाइक एक्सीडेंटल केस हो जाता है. ठीक है ना, या कुछ ऐसा मार पिटाई हो गया तो पर्सन को चोट लग गया ना, तो ना ही विल नॉट एबल टू कम, देन पुलिस विल गो टू द. एंड इन सच केसेस में क्या होता है, मजिस्ट्रेट शुड बी देयर. मजिस्ट्रेट इज गोइंग टू टेक द रिकॉर्डिंग. क्लियर. सो इन द प्रेजेंस ऑफ मजिस्ट्रेट पुलिस इज गोइंग टू फाइल एन FIR in the presence of magistrate only. Correct. And recording of the statement shall be videographed. Recording of the statement shall be videographed. Recording of the statement shall be videographed, and a statement is recorded by a magistrate. Then abhi next is Next question is, who can arrest? Okay, so for example, who can arrest? Options, for example, they have given like police officer, second is magistrate, third is, for example, military officer, fourth is like private person. अब इसका कोई मतलब नहीं है. So who can arrest actually? आप multiple options में choose कर सकते हो. 1 2 1 2 3. You can make your own option. Who can arrest? Yes. Okay, एक ही चूज किया है. ठीक है. All actually. ठीक है. ठीक है. So police officer definitely can arrest. Military officer, he also can arrest. Magistrate also can order, and private person also, like you also can arrest that individual. ठीक है. तो see, आप already police, आपको पता ही नहीं था. ठीक है. If, for example, you have seen someone has done the crime, you can also arrest that individual, but within 6 hours you have to give that individual to the police. Within 6 hours, correct? So you can write within 6 hours private person का. Within 6 hours, if private person is going to arrest, then within 6 hours person need to be given to the police actually. Clear? Abhi done. So everyone, next is, for example, so अगर for example cognizable offense है, cognizable offense, in cognizable offense arrest without warrant permitted. Yeah, arrest without warrant permitted. And in non cognizable offense, arrest only with warrant. In non cognizable offense, arrest is only with warrant. Correct? Even for example, when non cognizable offense is there, यहाँ पे arrest can be done without with warrant only. But still actually the police has right to arrest that individual in non cognizable offense also, if that individual is actually hiding the identity, if they are not providing the identity, correct name they are not giving, correct, for example, address is not giving, then police can arrest that individual. Like for example, defamation जो है, defamation is a non cognizable offense. यहाँ पे you are going to report, police will not going to arrest the accused. But if, and then police is going to ask the accused कि furnish your information, like what is your name, what is your address. अगर आप you are giving false information, you are not giving this information, then police may arrest you actually. Clear? So a person commit a non-cognizable offense in front of a police officer, and if he refused to give his name and residence or give false information, then definitely police can arrest that individual without warrant also. Then agar name and everything is given, then police will going to release on bond only. Done this. Now suppose example, this offense is done by the member of the armed forces. Then what, police can arrest that individual. Okay, So no member of the armed forces of the central government shall be arrested without consent of central government. Correct है? So no member of the armed forces of the union shall be arrested except after obtaining the consent of the central government. Correct? That means you should not just inform the central government and then arrest that individual. No, you have to take the consent of the central government. If you are not getting the consent, you cannot arrest the member of the armed forces of the central government. Clear? Done this? Yes? Yes. See, retired also, for example, it is there. Retired, this scope is not there. Retired persons can be arrested, okay, because you are not now under central government. Clear? But not for the work you have done in official capacity. Like for example, you are arresting for that what work he has done in official capacity. So because for example, before retirement he has done something. Now you are going to put an FIR and going to arrest, then you have to take permission of the central government. Clear अभी? अरेस्ट तो हो गए, अब बेल भी मिल जाए, ठीक है. सो नेक्स्ट स्टेप इज बेल. So this is coming from one term that is called as, from the French term baillier. What is the meaning of this term? It means to deliver or hand over. Okay. So in one of the case, like in Gurbaksh Singh, Supreme Court has given what is the meaning of the term bail. Okay. So bail basically requires two things. Two things requires. First is liberty is restored. Second is security is furnished. So bail जो है, it is a temporary release. It is not permanent release. It is a temporary release only. Permanent release तभी होगा when case is going to finish, you have completed your punishment or you were acquitted by the court. That is only permanent release. This is temporary release. So CRPC has never defined what is the meaning of the term bail is there. Now, BNSS has given three sections basically, like section 2B, section 2D, and section 2E. Three sections are there. This section talks about bail. This section bail bond. This section talks about bond only. So bail means release of a person. Okay. Yes. Accused only will going to get the bail. Yes. Because still actually the thing, see, accused कौन होता है? Accused does not mean that person has done the crime. We need to find out after trial only whether this person has done the crime or not. Suppose person A, you said that this person has committed the offense, but may possibly that person has not committed the offense. It was a false FIR only or not. So that is the reason is the accused is having the bail only. So bail, I told you, it is a temporary release only. It is not permanent release. Okay, you can be arrested again also. ओके, बेल बॉन्ड क्या होता है? अंडरटेकिंग फॉर रिलीज विथ श्योरिटी, कुछ मनी के साथ. ओके, सो ए अंडरटेकिंग फॉर रिलीज विथ श्योरिटी. विथ श्योरिटी मीन्स क्या होता है? विथ श्योरिटी मीन्स सम अदर इंडिविजुअल विल बी देयर, दे विल टेक द, okay, this key, I will take care of this. If he is not coming, then it is my duty to bring that individual to the jail. So with surety. What if that person does offense after coming out of jail? फिर से पकड़ लेंगे और क्या है? That's it. Yes, two offense हो गई. When two offense, if you are having multiple offense, then to get bail is very difficult then. Okay, so bail का भी ऐसा नहीं कि automatically by default you will get the bail. If suppose example you have done multiple offense, एक साथ, okay, 1 2 3 4, and then you, police has actually arrested you, then there is no guarantee that you will get the bail then. Clear? So bail bond क्या होता है? Whenever undertaking for release with surety. With surety means someone is taking the responsibility, and this is bond. This is bond means personal bond without surety. This is personal bond without surety, because many of the times क्या होता है? Because person क्या, they are तो जो those who are migrated person, okay, they migrated to other city or other state. अब no one will be there to know who are these guys are there, and they are inside the jail. Like for example, someone is migrated from Madhya Pradesh to Karnataka. He has done the offense here. Now he wants bail. Up in local area like in Bangalore, no one will be there to take the security. So at that time, he can give personal bond also. So that is called as bond without surety. This is bond with surety.
Sir, what is the time duration for bail?
अभी बताएंगे. Okay. I will discuss about all those types of bail and all those items. अब आता है for example bailable offense and non bailable offense. Okay, one is bailable offense and this is a non bailable offense. So this is less grave offenses. Okay, and this is grave offenses like assault, rape, murder, these non bailable offense. So here bail is a matter of right. Bail is a matter of right. Here bail is a matter of discretion. Discretion of magistrate. This is granted by police or court. Both can grant you. This is granted by court only. Okay, so this comes under section 478 of BNSS, and this comes under section 480 of BNSS. Clear अभी? So again, ऐसा नहीं कि bailable offense is always a cognizable offense, or non-bailable offense is a, or for example non-bailable offense is a cognizable offense and bailable offense is a non, ऐसा there is nothing. There are some exceptions also will be there. Okay, so if question is coming कि non-bailable offense always will be a cognizable offense, ऐसा नहीं है. ठीक है? Cognizable offense only those offense which are listed under schedule 1 of the BNSS. That's it. So who can grant the bail? Like in bailable offense, court as well as police. Because when police is going to arrest you, within 24 hours they need to present you before the magistrate. Okay. At that time, for example, before the police is going to present that person in the magistrate, आपने देखा होगा in the movie, अभी अभी अरेस्ट किए थे, वकील साहब आगे कागज लेके, सी बेल बॉन्ड इज देयर, Now police has nothing. Police can release that. That is, police is going to give the bail now here. Correct है ना? Or for example, when this police has presented that person before the magistrate, then that advocate, he can go to the magistrate also. He can say, I am having a bail of that individual. Then magistrate is going to release the individual. Clear? So this is your matter of right. This is your right. In this bailable offense, it is your right. You can ask the bail. Here also you can get the bail. But police definitely, like example, you have done an offense which is bailable, non-bailable offense. Police has arrested you. Within 24 hours के अंदर they need to present the magistrate, but still you are within the police lockup because 24 hours has not been done. Now, if you are reaching the police station, you will say, I am having a copy of bill. Police cannot give. Police will say, go to the magistrate. I am coming there only. ठीक है ना? Then magistrate will going to give the bail. So it is the discretionary power of the magistrate. Clear? Bail still will be available here also, but here it is not your right. It is the discretionary power of the magistrate. Clear? They will check. कैसा तो नहीं है. For example, if I give you the bail, you are going to destroy the evidence. Okay, you are going to intimidate the witness also, or you will going to run away from this country. If these things are not there, then they will give the bail also. Clear, Abhi? Any doubt? Yes, again he has done the offense. Okay. Yeah, there are, for example, in new BNSS में, if suppose example, if gang rape has been done with a girl less than 18 years old, okay, and that crime is there, then there is no provision of bail at all. Earlier this was 16 years under old CRPC, but they have increased the age to 18 years. So there are actually जहाँ पे bail is not be available at all. Clear? No, magistrate will not be. Correct? Clear? See, bail is a rule. It is not an exception. So whenever someone give, because bail is because still that person the person actually is not convicted yet. We do not know whether that person has done the offense or not. So that is the reason Supreme Court says in many times, bail jo hai, it is a rule. It is not an exception. Now comes the types of bail. Yes. Oh, okay, definitely we can go to. Okay, first session court, then high court actually. Clear? Types of bail now. First is regular bail, or we can call default bail. Regular bail, anticipatory bail. Okay, और default bail अगर हम लोग कर सकते हैं different default bail, or we can call interim bail. So regular bail we have already seen section 478 and section 480. कि अगर section 478 means bailable offense है, you will get the bail directly in the police station or magistrate. 480 non-bailable offense है, then magistrate also can give you the bail. That is regular bail actually. Correct है? Anticipatory bail क्या होता है? That is mentioned under this section 482. So anticipatory bail means you are anticipating you may be arrested. Before they are going to arrest you, you are going to ask for the anticipatory bail. Who will give this bail? Session or High Court. Session judge or High Court. That's it. Clear this? Anticipatory bail. So anticipatory means you think that you may be arrested. Before you are going to be arrested, you have taken the anticipatory bail directly from the session courts or High Court. Now you will not be arrested. So this is mentioned under section 480 of BNSS. Then this समझ में आ रहा है? अगर you are already arrested, can you take anticipatory bail? नहीं भैया, already you are arrested now, so you will come to regular bail then. Clear? Next is default bail. Default bail क्या होता है? Suppose example you have done a crime, okay, where actually punishment is 10 years plus. Okay, suppose example यहाँ पे if you have done जहाँ पे punishment is less than 10 years, और एक है जहाँ पे offense you have done then punishment is more than 10 years or life imprisonment or death. This punishment you will get if you have done such offense जहाँ पे you will get punishment that is more than 10 years or life imprisonment or death. So what is the thing is there here actually within 60 days actually, like 60 days have been passed, 60 days have been passed, okay, and police is not able to file the charge sheet. You are arrested already, 60 days have been passed and police is not able to file the charge sheet. On 61st day you can get the bail. Correct? It is now a matter of right. But if you have done the crime where 10 plus or life imprisonment or death sentence is there, here if suppose example 90 days have been passed and police is not able to file the charge sheet, you are having a right now to get the bail. Done this? Default bail clear? So that is the reason it is called statutory bail also, because it is in the rule, it is in the law, statutory. Now interim bail kya hai? Interim bail is short term. Interim bail is short term, correct? ये कैसा short term होता है? For example, already your this bail already, like for example regular bail के लिए you are already applied, okay, but still you are not able to get this regular bail, and there is a requirement, like for example you require medical, okay, this help, so you require that you need to be, okay, released by the police. So at that time at least you can take the interim bail, then high court will provide you the interim bail in between, so that till the this is going to be discussed you will get the bail, and after jiska result aa gaya, for example result came in no bail, then you will be arrested again. If they say yes, bail is given, then already you are released. That is called as interim bail. So it's just like for example when we are covering president का pardoning power, वहाँ पे वन था to stay on the execution of the punishment. What was that? क्या था? Reprieve, respite था कि नहीं? Yes. क्या था? Remission. अब तो तीन ऑप्शन हो गए, ठीक है, करेक्ट है? सेम वे दिस इज का interim bail only, correct है? Because already your paper is going for the regular bail, but you are not able to get the regular bail because of some reason, okay, you require immediate release, because reason क्या होता है? You are old, or for example you require medical, okay, help, at that time they can provide you the interim bail. Clear अभी? Any doubt here? Yes. Preventive detention also, yes. Yes. Then this Okay. Now there is also one rule, different maximum period, basically in under trial case. Under trial case, okay. If suppose example, एक है half rule. One rule is normal rule. What is half normal rule? Is it when, for suppose example, someone has already completed one half of the maximum period of imprisonment specified for that offense. Like example, I have done an offense X. For that maximum punishment, if I convicted, I will get like 10 years, and 5 years already I have completed in the jail. Then I have my right that I will get the bail. Correct? Hai? That is called as half rule. So you can write when an under trial has undergone detention, when under trial has gone has undergone detention up to one half of up to one half of one half of maximum period of punishment, maximum period of punishment maximum period of punishment is specified for that offense, is specified for that offense. Okay, is specified for that offense, then he shall be released by the court on bail. He shall be released by the court on bail. He shall be released by the court on bail. Clear abhi? Ekdam. Now one more rule we are having, that is called as 1/3. If suppose example someone who is first time offender, he has never been convicted for any offense in the past. If he has completed 1/3 of the total punishment he will get if he convicted, then he also can be released on the bond. 1/3. So you can write it is basically for a person who has never been convicted. A person who has never been convicted of any offense. A person who has never been convicted of any offense in the past. A person who has never been convicted of any offense in the past shall be released on bond. Shall be released on bond after completing 1/3 of maximum period. After completing 1/3 of the maximum time period. Done abhi? Now, when we were covering like 60 days, 90 days time, the 60 days completed, then person has right to get bail. 90 days completed if charge sheet has not been filed, then also. Same way, यहाँ पे we have completed. This is not a rule that it should be applied. यहाँ पे भी some exceptions are there. Exceptions ये कि delay caused by the accused. अगर सोचो example कि if delay is caused by the accused only, he is not completing. Okay, at that time, whatever the day he wasted, those days will not be counted actually. So exceptions you can write delay caused by the accused to be excluded. Delay caused by the accused. Delay caused by the accused is to be excluded, is to be excluded while computing the time period. So this is the first exceptions. Second exceptions क्या है? Second exception, public prosecutors. Public prosecutors argument. If public prosecutor is arguing that bail should not be given and if court has accepted, then also bail will not be given then. Public prosecutor कौन होता है? See, for example, in any of the case, there are two individuals are there. One is victim, other is accused. जो victim side से होता है, that is called as prosecution side, prosecution wing. Okay, so this is public prosecutor here. And इस side से accused side से he is defense. So public क्यों होता है? Because he is a government lawyer actually. Because whenever you do any offense, the offense is considered always against the state only. So that is the reason this side से always will be the public prosecutor. Correct है? And this is defense. So if public prosecutor says that bail should not be given and if court has accepted, then bail will not be given then. Clear? If someone has done more than one offense, then also bail can be denied. If someone has done more than one offense, then also bail can be denied. देन अभी बेल का एकदम क्लियर मामला. Next is, so first done, second bail, third will be trial. So trial क्या होता है? Where court examine the evidence. Trial means when court examine the evidence, hear the witnesses, makes the determination. Okay, so what is the trial means? Trial simple means court examine the evidence, okay, hears witnesses and make a determination. Hear witnesses and makes a determination. Correct है? Makes a determination. Determination means whether criminal liability है या नहीं. So every trial will end in two way. Either will be conviction or acquittal. यही होगा ना? Either conviction or you will get acquitted. One more actually term you will get, that is called as discharge here. Court has discharged it. Okay. So discharge होता है, discharge is not an outcome of trial. ध्यान रखना, this is very very important यहाँ पे concept clear के लिए. Discharge is not the outcome of trial. Discharge will be done before the trial only. Trial शुरू ही नहीं हुआ. Court has discharged the individual. Why? Because charge sheet you have filed. There was no prima facie evidence. Court was not ready to accept the charge sheet. Then they will discharge the case. ठीक है? So discharge is not an outcome of trial. It happens before the charge is framed. Discharge is not an outcome of trial. It happens before the charge is framed. That means before the trial has begun. Yes. So acquittal means completely released actually. Okay. Clear? Conviction means now punishment will be given. Then this, now four types of trial is there. There are four types of trial. First trial we called session trial. Second, warrant trial. Third is summon trial. Fourth is summary trial. Session trial actually serious cases. यहाँ पे only session court will take the case. Session trial only by the session judge we will start. Okay, only for the serious cases. Warrant trial, this is also applied but less serious. Okay, so that can be done by magistrate also. Just see, होता क्या है in if you go to the subordinate court, okay, उसमें क्या होता है जुडिशल मजिस्ट्रेट होता है एक फर्स्ट क्लास, ओके, एंड जुडिशल मजिस्ट्रेट सेकंड क्लास एंड चीफ जुडिशल मजिस्ट्रेट, उसके बाद कहीं आता है आपका सेशन जज. सो सेशन जज इज वेरी वेरी सीनियर जज एक्चुअली. उसके बाद ही कैन डायरेक्टली बिकम द हाई कोर्ट जज. सो सेशन जज इतना तो नहीं खाली पीली बैठा है कि एवरी केस ही विल हियर. सो जो सेशन ट्रायल दैट विल बी डन बाय द सेशन जज, वारंट ट्रायल विल बी डन बाय these individuals. Clear अभी? Summon trial क्या होता है? Where no warrant is required. Non-bailable offense, sorry, bailable offense. यहाँ पे no warrant is required for arrest. Summon just by notice. Summon, that is the reason word is coming. Summon only without any warrant. That is summon trial. Summary trial is होता है for petty offenses less than 3 years. चालान किया है, आ जाओ एक साथ कर दिया summary trial. Because whenever for example चालान or something issue happened, so वहां पे they do like this only. Summary trial is, summary trial कौन करेगा? ये जुडिशल मजिस्ट्रेट फर्स्ट क्लास, सेकंड क्लास, इवन और सीजेएम आल्सो. चीफ जुडिशल मजिस्ट्रेट. That apply to the petty offenses, small offenses only. Less than 3 years, yes. One or more. Because the thing is, there is a national portal is there. So in the national portal, you can find out. So it is not like that, for example, you have done the crime here, okay, then Delhi police is not aware about it. They will search over there in national portal. There is a record is available. So in entire India, anyone can access all the police stations. Clear? Yes. Yes, even in for see entire investigating agencies, they are able to get access that information. So earlier it was not the cases. I think after 2011 they have done this record digitizations. So now it is available to everyone. Correct? Hai? Done this? Now उसके बाद ट्रायल स्टार्ट हुआ. Okay? Session trial. We will cover session trial basically. Trial, session, trial. So stage first is क्या होगा? Whenever it starts, trial to be conducted by a public prosecutor. सबसे पहले trial to be public prosecutor. So here opening the case by public prosecutor. Okay, yes, P dot P, public prosecutor, he will going to open the case. So when accused appear or brought before the court after commitment of the offense, prosecutor open the trial by describing the charges, correct है ना, or outlining the evidence. कैसे करेगा? He will going to describe the charges, these charges have been applied, and outlining the evidence. Clear? अभी क्या होगा? Discharge, because अभी still trial not started here. Okay, they have just tell. यहाँ पे जो accused है, he can go for discharge also. Discharge. Okay, so application, accused can file an application for discharge within 60 days. Within 60 days. When this is started, uske within 60 days, accused can file an application for the discharge. So यहाँ पे क्या होगा कि if suppose example judge consider there is no sufficient ground, okay, for the proceeding against the accused, then judge shall discharge the accused and record his reason, case and hereon. समझ में? अभी ट्रायल शुरू भी नहीं हुआ, because only public prosecutor is informed only these are the charges, these are the evidence. उसी में within 60 days if accused has filed the application for the discharge, correct, charge sheet already have been filed now. Okay, now if judge think that there is no sufficient ground is available for the proceeding against the accused, then he shall discharge the accused and will give the reason also. Case done. ठीक है? अगर ये नहीं हुआ then क्या होगा? Framing of the charges. Correct? If not, then we will, agar yes, then release, correct, and then will come to framing of the charges. Framing of charges. So you see, charge or discharge, whose discretion is this? Judge. Judge can discharge also, judge can charge also. Okay, so after receiving the case, if judge is of the opinion there is a ground to presume that accused has committed an offense, then judge is going to frame the charges. Clear? Whenever they frame the charges, they will check this also, whether this matter need to be tried by the session court or by any other court. If उनको लगा कि whatever the BNSS sections are there, they need to be dealt by the lower court, then they will transfer the case to that lower court. If they think that this need to be tried by this session court only, then they themselves will continue. Clear अभी? Now next is, जब charge हो गया, now next क्या होगा? Fourth, because there is sufficient ground is available to presume that accused has committed the crime. Now conviction on plea of guilty. Guilty. So यहाँ पे क्या होगा? For example, so whenever charge is framed, then जज जो होंगे, charge is read and explained to the accused, आपके ऊपर these charges have been done, whether you plead guilty or not. If बोलेगा plead guilty, then there is a conviction or trial continue. So it is a discretionary power of the judge whether to accept. If accused has said that yes, plead guilty, I have done the crime, then At that moment also judge can convict that individual and punishment will be given. और जज को लगता है नहीं, this person is doing all this under pressure, some other individuals are also involved, okay, these things, or this is not able to understand the charges also, he is just saying yes yes I have done, okay, इसका मतलब he is a driver of that rich individual, ठीक है. ऐसा होता है ना, बड़े बड़े लोगों के ड्राइवर हेल्पर दे टेक द चार्जेस बाय टेकिंग 1 crore rupees 2 crore rupees, सेम, देन ट्रायल विल कंटिन्यू. क्लियर अभी? If not guilty, then definitely trial will continue then. Correct है? If not, तो फिर बोल देंगे डेट फॉर प्रोसिक्यूशन एविडेंस. If accused does not plead, refuse to plead, or claims to be tried, then क्या होगा? They will fix a date for the examination of the witness. Then witness will come, evidence will be shared there. So on the fixed date, judge is going to record all the evidence produced in the support of the prosecution. All the witness will come, they will record their statement. Clear? उसके बाद क्या होगा? They will do cross examination because still everything is coming from the prosecutor side. Defense also will going to prosecute things. Clear? अगर सोचो एग्जाम्पल आफ्टर डूइंग ऑल दीज थिंग्स, ओके, नाउ जस्ट थिंक दैट की जो जो ये बोला था दिस एविडेंस दैट एविडेंस ऑल आर फालतू, ओके, then judge can make acquittal also, okay. So here if whatever the evidence presented by the prosecution side, whatever the witness presented by the prosecution side, and judge is also going to do little bit cross examination also, if just think that there is no evidence that accused committed the offense, then acquittal. Correct है? If there is judge found that there is no evidence that accused has committed the crime, that is called as acquittal. So acquittal and discharge is different now. Discharge on stage 1 itself before trial begins, this is after trial only. If accused not acquittal, यहाँ पे then entering defense stage. अब defense will come. Then defense will produce the evidence. Defense will produce the witness now. Correct? Both side फाइट करेंगे एक दूसरे से. भी असली जो आप मूवी में देखते हो वो ये स्टेज पे होता है, ठीक है. आर्ग्यू. Then one day will come for the judgment day, and judgment में again conviction or acquittal. Done this. If convicted, then judge will going to hear the case for the punishment, because convicted does not mean punishment will be given on the same date. If the accused is convicted, then judge shall hear the accused also on the question of sentence before passing the sentence according to the law. Clear? So conviction date different होता है, sentence date will be different. Clear? First conviction, then they will set the date. In this particular date, I will going to announce the sentence. डन है अभी? समझ में आ गया केस? एकदम इजी है केस, आपका केस समझ लो, ठीक है? You have done the crime. Okay, charge sheet will be filed within 60 days or 90 days. Charge sheet is filed, then session court में case is there, they will check about this charge sheet, and then public prosecutor also will frame the charges. If suppose court think that ki there is no proper evidence is available against the accused, that accused has committed the offense, then court is going to discharge the individual. So discharge is releasing of the individual before the trial only, correct? If court को लगता है नहीं there are sufficient evidences there, then court is going to frame the charges. Once charges has been framed, then what will happen is they will ask, they will going to explain the charges to the accused, correct? These charges have been framed against you. You plead guilty or not? If we say here plead guilty, conviction there, sentence is there. If court think that just think that this person is saying this under pressure of someone, he has not done the actual crime, then trial will continue, correct hai? If not guilty, then again prosecution side ke liye one date will be fixed. Prosecution will going to produce the this evidence as well as witness. Then again judge sahab will go through the prosecution side's evidence as witness and they will cross examine it. If judge को लगता है कि नहीं this all are not sufficient, then again they can give the acquittal to the individual. So again that the accused will be released. अगर जज को लगता है नहीं there are sufficient evidence is there, this case should continue, then what will happen is defense will enter now. Now defense will produce their own evidence, their own witnesses, then argument will happen between prosecutor and defense. Okay, after all these things, then court will determine whether conviction or acquittal. If conviction, then again they will going to hear how much sentence should be given to that particular accused. Clear अभी? एक मूवी हो गया. Done. Okay, now comes to arrest and custody. Yes, trial will be in every case actually. Okay, now arrest and custody. What is the difference between arrest and custody? इंटरव्यू में क्वेश्चन आ गया है एकदम को आपको लगा आई विल टेल, देन बोथ लुक सेम ओनली, ठीक है? यस, अरेस्ट yes, arrest is okay, and custody, okay. See, for example, one is I am here, okay, 4 police personnel come near me, this is arrest or custody? Now this is custody, okay. Custody is a wider definition. Custody means they are not giving you liberty. For example, you are free, आपको मतलब for example रोड पे खड़े हुए हो, but आसपास 4 to 5 police personnel are there, they are not allowed to move actually out of that circle. They can say that I have not arrested you, किसी ने आपको पकड़ा भी नहीं, they have not touched you even. So this is custody. Custody means whenever liberty is not available, that is custody. Arrest क्या होता है? Arrest is taking a person into custody by legal authority. Okay, so simple is like example, if we need to check like this is arrest. This is custody. So custody is a big circle. Arrest comes under that itself. Every arrest lead to the custody. Every custody will not go to there, correct or no? So simple thing is this, कि arrest is a subset of custody. Custody is having a wider definition. Okay, आपको बस पकड़ लिया, that is custody only, correct है ना? या for example, court has informed you have to come over there, आप वहाँ के खड़े हो, that is custody only, that is not arrest. Correct, clear is this? Done. Next is like a person who has surrendered before a court, that is under custody only. You are not arrested. A person who surrendered before the court, that is a custody. Now, for example, whenever आपने कोई crime किया, you have done a crime or something, पुलिस ने arrest किया आपको, हो गया, crime done, FIR हो गया, then you are arrested for example, पुलिस ने आपको पकड़ लिया custody में, ठीक है? अभी क्या होगा? Now there is one article number is there within 24 hours. What is article number? 22. 22 only, correct? So 22 within 24 hours you have to produce before the magistrate. Okay. So now within 24 hours person need to be presented before the magistrate. So it may be possible that they have actually, for example, once offense is committed, arrest is made, investigation begins. Now investigation completed within 24 hours only. Then no remand is needed. Police is going to release you. Understood? Okay, within 24 hours they have done entire investigations and they said no, I do not require that. Then police can release you. Okay. Investigation not completed within 24 hours, then section 187 is triggered. Bail wala tha na, regular bail. So whenever 24 hours done, then section 187 will be triggered. Then accused must be presented before the magistrate. करेक्ट है? अभी यहाँ पे देखना फॉर एग्जाम्पल, अब यहाँ पे टू टाइप्स मजिस्ट्रेट इज देयर. वन इज जुडिशियल मजिस्ट्रेट, अदर इज एग्जीक्यूटिव मजिस्ट्रेट. वन इज जुडिशियल मजिस्ट्रेट, अदर इज executive magistrate. Judicial magistrate means judicial magistrate first class, second class, or chief judicial magistrate. What is executive magistrate? DM, SDM, तहसीलदार, they are comes under executive magistrate. अभी क्या होगा? Where will you go? Executive magistrate or judicial magistrate? Police will go to the judicial magistrate. Judicial magistrate क्या करेगा? Judicial magistrate will decide. This is 15 days window. Judicial magistrate will send you either police custody or judicial custody, but police custody maximum 15 days. After that you will be in judicial custody. ऐसा नहीं कि every case में police magistrate is going to send you under police custody. No, in very rare case magistrate will allow police custody. In most of the cases में, अगर for example case is not genuine, then magistrate will say release this individual. If that individual actually has done the crime, there is a prima facie evidence is there, and then police is asking that I require police custody, but still I have not completed the investigation, then he will be sent to the police custody. But maximum police custody is possible 15 days. Correction? Or you will be sent to the judicial custody. क्लियर अभी? Now judicial custody में they can live how many days? One window is 60 days, other window is 90 days. That means if charge sheet has not been filed and 60 days completed, then automatically you will get the default bail. Okay, in which case where you are having less than 10 years punishment, यहाँ पे plus 10 life imprisonment और death sentence. Clear समझ में आया भाई? So who will decide this? Judicial magistrate will decide all these things. Judicial magistrate will decide these things. Done. So 15 days maximum police custody, 60 days maximum judicial custody, and 90 days maximum judicial custody. Clear abhi? So police will go within 24 hours. Where? In which magistrate? Judicial magistrate. Okay. If question is coming this way, if police need to present the accused within 24 hours, always before the judicial magistrate, not executive magistrate. Correct? Statement correct or incorrect? जो आपको लग रहा है उसका अपोजिट इज द राइट आंसर. वो क्या लग रहा है? आप कुछ भी सोचो, उसका अपोजिट विल बी द राइट आंसर. ठीक है. So yes, if judicial magistrate is not available, then he can approach to the executive magistrate also. समझ रहे? So if judicial magistrate is not available at that time, because 24 hours done, it is the duty of the police need to present somewhere. वो ले लेके घूम रहा है, किधर जाए? And judicial magistrate, he went to marry someone, then he need to present it before the executive magistrate. So who is executive magistrate? Example, DM, SDM, even तहसीलदार is also executive magistrate. अब ये executive magistrate क्या करेगा? इसके लिए भी तो प्रॉब्लम है. लेके तो आ गए, what should I do now actually? Because you are coming under me only. Conflict of interest is there. Okay. So he can do what? He can allow maximum 7 days police custody as well as judicial custody. That's it. उसके पास इतनी ही पावर है कि ठीक है, he can decide कि whether for 7 days you can go to the police custody or judicial custody or whatever. Correct है? Clear? So who will decide now? कितना टाइम के लिए maximum? 7 days. 7 days can be police also, 7 days can be judicial also, but not more than 7. अगर more than 7 you need, then you have to approach to the judicial magistrate only. Clear? Done. अब next thing is this. तो ये चीज clear हो गई कि yes, executive magistrate also can do this. Now this 15 days window जो ये 15 days, this 15 days need to be coming initially 15 days or any time 15 days. That is also one of the issue. Yes.